Hello, this is Shelley Pulaski, and this is my presentation on Bobby versus the School Board of the City of Norfolk, Virginia. The background on this case includes the participants of the minor child with autism, LGB, in the court files, her parents, Christopher and Ginny Bobby, the school board of the City of Norfolk, Virginia, and each of their attorneys. The original complaint stemmed from when the parents initially tried to accommodate their daughter's special needs through their private school. No agreement was made, and the IEP suggested their daughter be placed in a public school. The parents refused this, so the Southeastern Cooperative Educational Program filed for due process to enforce the plan over the parents' objection, resulting in a drawn-out court battle, which ultimately led the SCEP demanding payment for attorney fees. The constitutional question involved is under the IDEA Act, the Individuals with Disability Act, are the parents legally required to pay the attorney fees of SEP? Generally, in law, a litigant must pay his or her own attorney's fees in the absence of a statutory or enforceable contractual provision allowing attorney's fees to be awarded to a prevailing party. In this instance, although the parents did not win their court case, it did not automatically be found that they had to pay the attorney's fees for their opposition. IDEA grants court discretion to award reasonable attorney's fees as part of the costs for actions brought under the certain statute. The ultimate argument brought by SEP was that under IDEA, a prevailing party, which ended up being them in the original case, who is a state educational agency or local educational agency, against the attorney of a parent who files a complaint or subsequent cause of actions that is frivolous, unreasonable, or without foundation should pay attorney's fees. So the SEP's argument was that the Bobby's complaints were frivolous, unreasonable, and without foundations. The SCP claimed that the Bobby's actions filed in court in the fall stem from this previous decision. At the start of the court system case, the parents again had initially wanted to try to accommodate their daughter's special needs at their private school. Since no agreement was reached, the SEP actually filed for due process to enforce the IEP plan over the parents' rejection for the good of the daughter. An independent hearing officer over the course of 5 days took testimony from both sides and interviewed 13 witnesses and had over 5,000 pages of documentations. It was seen that the independent hearing officer agreed with SEP, and then the parents filed their official appeal to the actual courts at that time. In January of 2014, the parents filed an amended complaint under the IDEA Act appealing the decisions of the independent hearing officer that confirmed the education plan for their minor child. The parents filed this motion as the final decision for the placement of their child was effectively being taken out of their hands. In March of that same year, both parties filed motions for summary judgment. Each party asked the court to rule that the other party had no case. They were both effectively saying there's no case here. The judge ultimately did take over that case and said, yes, I'm going to listen. In May of 2014, the judge decided in favor of SEP and denied the parents' motion for the summary judgment. In essence, the magistrate decided that there was evidence to move forward with the summary judgment on the part of SEP. In July, they then filed for motion to get attorney's fees in the memorandum of support, in which the parents ultimately filed their memorandum of opposition. In August of 2014, the parents filed their opposition. That again, they didn't agree with anything. There were multiple outcomes stemming from the original issues surrounding the Bobby's IEP. The record did not support the parents' claim that they were denied participation in the IEP process. In fact, all IEP sessions had been recorded. The Parents' Council also introduced no evidence that CESIP would be unable to meet their daughter's educational needs. The Council's claim that the IEP could not be implemented as written was also addressed in the IHO and was found to be not true. And though not groundless, the Council's challenge to the IEP's offer of a free, appropriate public education ignored the central purpose idea, when in fact it was what was best for the child in this case. Ultimately, the United States Magistrate Judge Douglas E. Miller ruled against the motion for attorney's fees and denied CESIP any money, although the parents really did not win in their little sections of their court case.